A very good time of the day, dear colleagues, and welcome to our interviews with institution series. Today, I have the pleasure to talk to Hyun Lim, Secretary General of the KCAB International. Good afternoon, Sue. How are you?
I am good, thank you. Thank you, and good afternoon to everybody out there.
Sue, established in 1966, the KCAB is one of the oldest arbitral institutions in the region. And over the years, the KCAB has administered thousands of arbitration and conciliation cases, proving to be the go-to arbitral center for domestic disputes. And as far as I understand, building on its historic success, the launch of KCAB International in 2018 seems to have been the logical development of the KCAB institutional practice. What prompted the decision to form an international arm of the KCAB?
Sure, and thank you for the question. And I think the better way to answer the question is not from within KCAB, but actually from outside of KCAB. And this is a process, the process of establishing KCAB International, a process that I was involved in not as a member of KCAB at that time, but actually a practitioner outside working in a large law firm doing international arbitration. And like you rightly mentioned, KCAB, or the Korean Commercial Arbitration Board, was established in 1966, but ever since its establishment, its main focus was on domestic cases between Korean parties in Korean language, and very much following the Korean litigation practice, just that the practice was much shorter and much cheaper. But as the Korean economy grew, it grew more global, Korean users became more savvy, and they had to bring in their international counterparts into arbitration. And obviously, the old way of doing international or domestic arbitration cases sometimes fit in with the international needs for administrating cases, but oftentimes it did not. And being a very old style institution back then, KCAB itself was staffed by people who didn't really have international arbitration legal practice background. They were more administrative workers. Not everyone, actually very few, had the linguistic capabilities to comfortably communicate with internationally renowned arbitrators. And that disparity between institutions' capabilities and the needs from outside was very quickly perceived by practitioners like myself from outside of the institution. And because there is a very strong ambient or atmosphere of voluntarism and involvement of arbitration practitioners into the institution, a group of arbitration practitioners, they proposed the plan to set up KCAB International, which will be an independent division from KCAB, but still within KCAB, so that all the clauses, all the pre-existing clauses in contracts with KCAB in their arbitration clause will be administered by KCAB, but the people overseeing those cases will be people from outside of KCAB who have proper practice or proper background in the practice of KCAB International. So that was the idea behind in 2018. And I guess the short answer was that it was changed, it was launched in order to meet the increasing needs to internationalize KCAB as a institution.
That's very interesting, Sue. So as far as I understand, the Korean arbitration practice grew from national litigation, and then based on the economy development, it became more international, it opened up, so to say, the borders. And the KCAB, so to say, preserved the brand identity, but internationalized its internal practices. And to that end, I see that there are several sets of rules of the KCAB, one for domestic disputes and one for international disputes. That's very interesting. Can you tell us a bit more what are the main differences between these two sets of rules?
Well, the domestic arbitral is a little closer to the domestic litigation in terms of the flow of how cases are managed. For example, the appointment of arbitrators is based on a list system. In a way, it's more common to the American Arbitration Association, the AAA, where you're given a number of 10 or 20 names and parties are asked to strike and rank within the names. Also, the level of compensation for the arbitrators fees were such that the presumption was that arbitrators' work was actually pro bono work, or a more public service as opposed to a proper legal professional service. Now, that probably did not sit well with many of the internationally renowned arbitrators who started to become aware of KCAB International, and also did not fit with what the Korean parties wanted in terms of persuading their foreign business partners to come to KCAB to arbitrate. So in 2007, and this was actually almost 10 years or more than 10 years before the launch of KCAB International, the KCAB back then, and even then with the help of many outside arbitration practitioners, created a new set of rules, the KCAB International rules. And to be very honest, it was as close as possible to the ICC international rules. Mm-hmm. And I quite say this with shamelessly because I think it's not because the ICC rules itself are more superior than others. I think it was very safely rooted in the UNCITRAL arbitration rules, which was familiar to most people. I am familiar with rules of the other reputable institutions around the world. I think they all share many of the traits of the UNCITRAL arbitration rules and the ICC rules. Of course, we don't have the particularities that ICC has, such as a separate court of arbitration, or we just don't have certain features that are related to their governance. But in terms of how arbitrators are appointed, how the communications are managed, they're very much in line with the common practice that most arbitration practitioners, or the ones in the international field, are accustomed to. And I think the philosophy behind it that time was that it's all fine and good to add your local flavor and do something peculiar or do something original. But I think because arbitration and law itself is is a field that stability and predictability is key, I think the real key word that any arbitration institution should vie for when they are preparing their rules, I think, is universality. Universality in terms of making sure that there's no provision that nobody expected, somewhere hidden in the corner, and later on someone will go say, got you, you didn't see that clause in the arbitration rules, and therefore threatening the validity of the award. That usually is not well received by users in arbitration. So the international rules are made in a way that is such that puts very much the practice or the expected flow of arbitration in line with the expectation of frequent users of international arbitration. And of course, I should add the composition level for the arbitrators have also been put to a more realistic level, but nowhere near the level of the larger institutions, which I won't bother to name here, but as users of arbitration, you will know which ones they are.
That's very insightful. So the Korean arbitration scene has been influenced by many practices, the best practices from the USA, from France, and I totally understand you're taking the ICC rules as the starting point for drafting, because to me, it's sort of a gold standard. They have been time tested, so you can take them and develop to tailor them to your needs. And my question is, you probably have seen that many institutions have amended their rules recently, or planning to amend them in response to the pandemic. Does the KCAB have any such plans?
Well, every year, or at least every year that I was here as Secretary General, which will be 3 years in a few months' time, we've reviewed whether there was a need to revise the rules. But every time we reviewed and considered it, I think the response or the answer back then was, to the extent that we can refine the practice of arbitration without touching the rules and reflecting through practice or through some public notice of interpretation, as much as we could do that, we would try to avoid rehauling or setting up a whole set of rules, because not only that creates something more to study for all these arbitrator practitioners and arbitrators, which is not always fun, but also the rules itself, the KCAB international rules are enacted in a way, were enacted in a way that are flexible enough to allow discretion to the arbitrators. So it wasn't overmanaged in terms of what the secretary would do or disallow. So there's always a room for maneuver in terms of how you put the actual practice in line to what everybody expects should happen in international arbitration. I know some institutions, they have a question of whether their rules allow non-physical hearings. Interpretation-wise, it would, but since there's so many people who just on the hope that they might get some new case, challenge the fact that the rules don't explicitly say that the hearings could be located virtually. I think there are some efforts to make sure that practice is reflected in the rules. But KCAB under the current rules, and also even the practice, even well before the coronavirus pandemic, the arbitrators were using the virtual setting for video conferencing or expert examination. So there was almost no resistance as to holding the hearing online as opposed to in person. I mean, if people insist on in person, I think it's for good reasons, and it doesn't take rules to tell them that. It doesn't take them, even if they had a rule in the provision or in the international rules that you can do virtual hearings. If there are needs for in-person hearing, I think parties are allowed to apply for it if they have a good reason. So yeah, the fact that the coronavirus disallows us to travel, that itself doesn't really prompt us with the need of having to revise the rules. But having said it, however, we are always looking into ways of seeing how we can renovate or add new innovative provisions into the rules without being too creative. And this year, 2021, might be a year where we, after finishing our review, we might embark in a minor revision of the rules, but we don't see plans for a major overhaul of the rules anytime soon.
Thank you, C. And since you mentioned physical hearings, unfortunately, there seems to be a common misconception among the parties, the end users, so to say, that the choice of a foreign arbitral institution presupposes they need to travel to that institution's locations. But since you mentioned that KCAB rules do respect the parties' freedom, to choose any seat and venue and conduct online proceedings, or just based on documents only, this, I hope, addresses this common misconception.
Absolutely correct, and I'm glad you pointed that out. And even as a practitioner in a law firm, I remember clients complaining that they didn't want this institution or that institution because they had to go to that city or this city. Nobody seemed to object about institutions in nice resort islands. I think the expectation was that they'll be able to go to those nice resort islands. But obviously, the meaning of a seat and a location of the actual physical location of the hearing is different. But regardless of their difference or their meanings, KCAB rules make it very clear that it's a party's choice of which seat they would like to designate. And we see cases, maybe not the majority of cases, but we do definitely see cases where KCAB rules are applied in the seat that is outside of Korea, outside of Seoul and Korea. So it's people who are savvy enough to know about what the seat are and take their time to look up Article 24 of KCAB International Rules, know that they have the freedom to decide the seat, and that the tribunal has full discretion upon consultation with the parties of where they will hold the physical hearing, if at all. I mean, they can actually do a fully virtual hearing. And those virtual hearings, I think, were like 78% of the hearings that took place in 2020 because of the corona pandemic.
I see. So the inherent flexibility and respect of parties' autonomy are two cornerstones or two pillars on which the KCAB rules stand. And I reckon they can very handy during the pandemic. How did the corona crisis affect the administration process, if at all?
So we're very happy to say that the hearings that were planned for 2020, except for maybe one or two, they just went ahead as planned, not physically, of course, because at least one party or at least one or two of the arbitrators had to travel from overseas, but that obviously was not possible. But it went on a virtual mode. The only two, maybe three cases that were postponed were actually supposed to have happened at the very beginning of 2020, when the situation was such that nobody knew how long or what the impact of it would be. I don't know if you've been reading the news back in early 2020, but when the first outbreak opened and started in China, in Wuhan, China, most of the cities outside of China was unaffected, except for Korea. Korea is actually the second largest place outside of, I guess, second only to China in terms of the initial infection rate, which was like, I don't know, 100 and 200, which is alarming everybody already. Now we have 2,000, 3,000 in some cities outside of Korea. But Korea has been able to contain that. But in the beginning, it was new. It was uncertain as to what happened. So cases that were scheduled that time, postpone a few months, thinking it might go on in person, but those cases ended up doing virtual anyways. They're postponed, but they went ahead virtually. So in terms of, did we miss any hearings because of the pandemic? No, not at all. Did we struggle because we were not able to administer cases? Not at all either, because we're lucky that the Korean government, although it was hit first compared to other countries, it was able to quickly assemble a very good containment plan. So while home-based work is recommended for many workplaces, people can show up with work. Nobody's told to stay at home. People can show up wherever they want. So there wasn't any actual or practical impediments of administering the cases, nor were there any delays. So yeah, I guess the answer to your question was there wasn't any difficulties during the administration of cases last year.
Well, I have nothing but to congratulate you on the success during the pandemic. And as far as the case numbers are concerned, I have different intel from different jurisdictions. In some jurisdictions, the pandemic resulted in the spike in cases. In some jurisdictions, the parties preferred to settle and not to commence arbitral proceedings. So in 2019, for example, the KCAB has seen a 13% increase in international cases. And what about the stats for 2020? What's the effect of the pandemic?
So I think that this goes back to the fact that there were no drastic changes in terms of the business scene in Korea, I think, thanks to the relatively well-managed containment efforts. So the numbers have been steady. We are not one of the jurisdictions that had a surprising spike of cases, nor was there a plunge of cases. It was basically very even compared to 2019. So in 2020, we had just for the international cases, I'm not talking about the domestic cases, but just for the international cases, we had 69 new cases, which is just one short of 2019, where there was 70 new cases that were filed. I guess if you add the ongoing cases that were spilled over, we would have about 100 cases active any time of the year. But although there was one case less in terms of case numbers, the value of the disputes that were filed in KCAB in 2020 showed an increase of 45%. So while there may be a noticeable little change, a dip in terms of case number, I think the qualitative aspect or the complicated aspect of the cases actually increased. And we use case numbers, or all institutions use case number as a rough barometer of how active the institution is. But there's a margin of, there's a little margin where it doesn't really much matter whether it came up or down, because what really matters is the qualitative nature of the case and so the case value, maybe the number of the parties involved, whether it was multi-claim, those also are, I think, are indicator of how busy an institution is. And those from those indicator viewpoints, I think KCAB had a pretty good year in 2020 and unaffected by the coronavirus.
Thank you, Sue, for sharing the statistics for 2020. It's very insightful. And I think the increase in cases value is the sign of trust in the KCAB, because at the end of the day, when you have a look at some new institutions, modern institutions, they may have many cases, but very small value claims. But in your scenario, the increase in cases value is what really matters. And what are these disputes? What disputes have been predominantly referred to the KCAB?
Yes, so the industry that we see the most are the trade business. So it'll be sales, distribution. And the answer to your question may vary depending how we categorize a case. So if the same case could involve trade among two international parties, but it might have an IP element to it. It might have some sort of entertainment element to it, but we don't categorize it as IP or entertainment. We just put it as trade because that is what the parties check. That's how the parties categorize it when they check the box. But I think most of the parties seem to perceive their case as a commercial trade dispute, and that is the bulk, about 40%, I think, of the case. The other 30-some% is related to construction. I think because Korean contractors being very active outside of Korea and inside Korea as well on cases, and no construction case goes totally with domestic elements. You have to have some supplier from outside, some engineer that has to fly in from overseas, a shareholder that's involved in the construction. So the construction cases, whether they're seated in there, whether the construction site is in Korea or a site, they tend to go to arbitration. And there's quite a number of cases that we see at KCAB related to international construction.
Mm-hmm. That's very interesting. So not only does the KCAB have a variety in terms of case numbers and case value, it's also about industries. Because as you correctly pointed out, yes, it may be international trade on the face of it, but there are some subtle elements like IP or M&A or something else. And construction industry, I think it's the driver of the dispute resolution industry worldwide, because we have seen and have witnessed the increase in construction disputes all over the world. So what makes the parties choose KCAB? What are the key advantages for arbitrating under the KCAB rules?
Well, I suppose the official answer to that is that it's the best institution in the world. But of course, we have to be very realistic. And I think the biggest driving force is the fact that Korean parties just prefer KCAB. And if they can, they somehow persuade their parties to come to KCAB. In terms of why a foreign party would want to select KCAB in the first place, the basic answer is that all the features, all the rules, it satisfies the requirement of universality. So it's predictable. It's a best practice. It's something you see everywhere. It's relatively more economic in a way that the ratio of administrative fees and even arbitrator fees, despite the fact that they're very much the same people you see in the institution, is a little less than the other larger institutions. Another really big thing, and this might be related to whether you have the virtual hearing in person or in virtual, is that if you have KCA rules and you end up with a hearing in Korea, you can use the KCAB facilities, which we have a separate name for. It's called the Seoul International Dispute Resolution Center. You can use those facilities for free. And the facilities, it's not some little room somewhere in a commercial building. It's actually placed in one of the nicest buildings in Korea, all glass rooms. with a great view. Of course, state-of-art technological support, the very nice lounge, nice computers, everything. You can actually use that for free, which is, I think, a feature that you would not see in any other institution. You would probably have to book a separate reservation and pay separate reservation fees if you want to do a hearing in that institution's hearing room. But in KCAB, it's provided for free. And even for arbitrations that are administered by other institutions, the KCAB or the hearing facilities of KCAB is free for anyone to use. Of course, that will come with a little fee, but it's still much more reasonable compared to nearby business centers that you would have to rent outside. And plus the staff, they know what arbitration is. They know how a hearing should be run, how many power cords you would need, how many internet connections you would need. So there's a high level of convenience that comes from conducting your hearing at the Seoul International Dispute Resolution Center. So I think location-wise, cost-wise, predictability, universality, I think all of those, I think KCAB hits all those key features of why you would like to go to arbitrate in an institution. And if you're a foreign party and you have to be the claimant, or you think you're likely to be a claimant, you think a Korean party will be on the other side. It's the reputation, I think the official or the I guess the renowned name or the authority of KCAB, I think that has a very large resounding effect on Korean parties. So it's a totally different thing trying to bring your Korean counterparty to some institution that the Korean party has never heard of, versus telling them, let's go arbitrate in your institution. And in terms of the level of resistance and the level of willingness to cooperate, it'll be very different if you're trying to persuade your Korean parties to come to KCAB. And even if you go there, it's just because it has the letter K in it, doesn't mean your Korean party has an advantage over you. The arbitrators are all, there's probably more non-Korean arbitrators in the panel. And of course, you're free to appoint anyone outside the panel as well. So in terms of who sees the merits, there's no bias in terms of nationality. And even Korean arbitrators, they're very proud, they're very professional. So there's no such thing as, oh, we've got a bias just because of nationality. They're very professional, they're very neutral. And I think they think of their reputation as neutral arbitrators very seriously. So it's not, I don't think there should be any qualms for foreign parties to come to KCAB to arbitrate their disputes.
Thank you, Sue. I think you have foresaw my next question, because more often than not, in international commercial arbitration setting, in particular when there is a sole arbitrator, the parties cannot agree. So how would KCAB appoint an arbitrator in this case? What are the qualifications or characteristics of the sole arbitrator the KCAB would look into?
So for the sole arbitrator, even for the chairperson, that cannot be agreed. There's a rule in KCAB where if any one of the parties say, we want a third national that's not same as the claimant or the respondent. So as a rule, the Korean arbitrators or the nationality of the arbitrators would rule out. Some foreign arbitrators, they don't really care because they know the substantive law is such that it's Korean law, and they can't really they don't really have the resources to produce their own legal expert in Korean law. And if it's someone that's reputable or they know has an inclination to be very international, they don't necessarily try to avoid a Korean arbitrator, a Korean national arbitrator. But if there's if there's a preference for a third party national, we are very strict. The Secretariat is very strict about making sure that there's no perceived advantage just because of one's nationality. So we try to keep a distance from the practice that we see in some institutions where there's some type of ongoing mission to make sure that the nationality or the parties of their same nationality are properly protected. That's not the stance that KCAB would take. So a perception of neutrality, the perception that everybody is given a fair chance to present their case. I think that's crucial to an institution. And once you lose that, you can't really take yourself seriously in the game. So that's something that KCAB International always has in mind when it appoints arbitrators, especially sole arbitrators.
Yeah, you're absolutely right, and I salute you for standing at the guard of arbitral process integrity, by ensuring that the parties are treated fairly in the appointment process. But what about diversity issues in appointments? How do you tackle them as the KCAB Secretariat?
Right. So diversity is also like a key mission. And it's true not only for KCAB, but probably for all institutions around the world, because we know that institution or the panel of arbitrators should properly reflect the representative of the diversity of the business environment. So, the business environment is full of people of different ethnic groups, of both genders, or maybe more than both genders, depending on how you classify them, and age as well. So the criticism or the attack that all arbitrators of complicated high value cases have to be male or pale, and male, pale, and with stale, I guess, because you see them too oftentimes. I think that's something that really hurts a lot of people's, I think it hurts the reputation of institutions overall. So KCAB, especially at least when we try to bring up the candidates to discuss and share to the parties, we make sure that there is a good number of diversity there. Not only age, gender, nationality, of course, is really key. But at the same time, we know that there is expectation of the parties about the arbitrator's reputation, whether they're tested or not, and also. For example, if you have two civil law jurisdiction parties who have a propensity of not going too far into document production or discovery or procedural side issues, instead of having a nice diverse group of common law lawyers, we try to compose the candidate list of people who we think both parties would like in terms of their legal background or their legal propensity. So it also depends on the size of the case. We don't want someone super busy who can only do hearings 2 years down the road for a mid-sized case, for example. So we would try to give a chance to someone younger who's more eager and more willing to take their busy time and look into the case file more closely and at an earlier stage. So there's a lot of balancing issues, but of the balancing elements, diversity is definitely key. And if you look at our panel of arbitrators, of international arbitrators, we see that, and if you take the different panel or the different editions each year, you could tell every year we've been trying to increase the number of women arbitrators into the panel. And the actual appointments, we are seeing a good number of women arbitrators. It's not because KCAB has a special soft heart for gender equality. I think it just reflects the fact that the good practitioners and good arbitrators out there, they're increasingly women are increasingly having a good share of that area. So we're actually following the reality of practice, but at the same time, we feel good about the fact that our statistics show that there are more women arbitrators actually appointed for these cases, and that number is increasing every year.
Thank you, Sue. I totally concur with you. It's not diversity for the sake of diversity. It's always a balancing exercise and recognizing the talent. So it's not that the KCAB or any other institution just appoint, someone for the sake of showcasing the statistics, but appointing the right person for the right case. And to that extent, serving the parties and the community, the arbitral community at large. Thank you, Sue. I think we have questions no more, and I strongly encourage our viewers to visit KCAB website, have a look at the statistics in more detail, and follow the KCAB on social media, on LinkedIn, on YouTube, on Facebook, to stay in touch with the institution and its development. Thank you so much, Sue, for sharing your insight with us today.
Thank you. And I should close by saying spasiba. Spasiba. And I guess, до свидания, or the next time we see each other.